So I declare that this first public hearing of the Standing Committee on Employment, Workplace Relations, Skills and Training for its inquiry into the operation and adequacy of the National Employment Standards. So I'm just going to introduce myself and invite my colleagues to do the same. I'm Karina Garland. I'm the member for Chisholm. I'm also the chair of the committee. We might start with Ms Roberts at the end here.
Roberts, member for Pearce, Western Australia.
Diley, the federal member for Fowler, Western Sydney.
Libby Kokab, member for Corangamite in Victoria on the Great Ocean Road.
Ash Ambihabaha, the federal member for Barton, which is on the southern part of Sydney Airport.
And Zoe McKenzie, federal member for Flinders, which is the Mornington Peninsula in Victoria.
Thank you very much. And I begin by acknowledging the traditional custodians of the lands on which we meet today and pay my respects to their elders, past and present, and extend that respect to any Aboriginal and Torres Strait Islander peoples joining us today. In accordance with the committee's resolution, this hearing will be broadcast on the Parliament's website, and the proof and official transcripts of proceedings will also be published on the Parliament's website. I remind all present that as Chair, I will ensure that proceedings are conducted in an orderly, respectful and courteous way. Those present here today are advised that filming and recording are permitted during the hearing. I remind members of the media who may be present or listening on the web of the need to fairly and accurately report the proceedings of the committee. I now welcome representatives from the Department of Employment and Workplace Relations and the Fair Work Ombudsman to give evidence for the Hansard record. Would you please state your full name and the capacity in which you appear before the committee? So we'll perhaps start from the far left and move our way across.
Good morning. My name is Emma Hallis. I'm Assistant Secretary, Senior Executive Lawyer in Employment Standards and Institutions Branch.
Good morning. Alana Maddock, Assistant Secretary, Safety Net Branch from the Department of Employment and Workplace Relations.
Anshu De Silva Wijaratna, Assistant Secretary, Equity, Entitlement and International Branch at DUA.
Hello, Diab Hub, First Assistant Secretary of the Employment Conditions Division at the Department of Employment and Workplace Relations.
Good morning all. Anthony Fogarty, Executive Director of Policy at the Fair Work Ombudsman.
Good morning. I'm Nikki Chaffer, the Executive Director of the Advice and Education Branch at the Fair Work Ombudsman.
Thank you. And I think we've got some witnesses online as well.
Rachel Volsky, Chief Counsel and Group Manager, Legal and Policy Group at the Fair Work Ombudsman.
Thank you.
Morning, I'm Joanna Williams. I'm a Principal Lawyer at the Fair Work Ombudsman.
Thank you. Okay, so although the committee does not require you to give evidence under oath, I should advise you that these hearings are formal proceedings of the Parliament. Consequently, they warrant the same respect as proceedings of the Parliament itself. Giving false or misleading evidence is a serious matter and may be regarded as contempt of Parliament. I now invite you to make a brief opening statement or statements, if you'd like, before we proceed to discussion. So were there some opening statements people wanted to make?
No, the department's
Right,
not
well, I can see some shaking of heads, our virtual attendees as well. So let's launch straight into it. I obviously invite my committee members to let me know when they'd like to ask a question, but I may use my chair's prerogative to begin some of the questions here. Now, there are a lot of, thank you very much, both of you, for both organisations for the submissions that we've received. There's a lot of really important information to take in there. Now, I think something that's really that came out quite strongly, particularly from the department's submission, was the need for the national employment standards, of course being universal, to be really well understood by all Australians. So just in terms of that, how adequate do you think the way that we communicate those employment standards are to Australian workers?
I might firstly start, and actually I might at some point pass to the Fair Work Ombudsman, given the question around understanding of standards and given the role of the Fair Work Ombudsman. We obviously as the department recognise that the national employment standards are designed to be a set of minimum standards, and to that end set out very clear principles for what should guide those minimum standards. it obviously sits within a system which we see as a pretty clear and simple layer of entitlements that is within the context that the national employment standards supported by the national minimum wage, the modern awards, and then enterprise agreements. And if you think of that as, in our mind, a hierarchy of entitlements, with the NES sitting as the foundations and the others building on top of that, it does provide a pretty clear and simple framework for what the NES provides. But in terms of specifically understanding and those sorts of questions, I might pass to Mr Fogarty, who probably sees that a little bit more at the Ombudsman.
Thanks very much, Dad. I'll start here, but very happy with any of my colleagues want to jump in as well. So the Fair Work Ombudsman is the agency that's responsible for providing advice and ensuring compliance with the Fair Work Act, and which obviously includes the NES as, the underpinning safety net, core set of entitlements for workers. We go about that in a number of ways. Our primary source of information is our website, and I can talk through some of the data. We have really high levels of engagement with the community there, and then really our approach is to then funnel down. If people can't find the information required via the website, then we've got a Fair Work info line, which again has a much smaller proportion of people that come to the website, which I can talk through. And then we also have a small business helpline as part of the Fair Work info line. Small business are an enduring priority for us as well. We want to ensure that we know that if small businesses get things right in the first place, then that means that workers are going to receive their entitlements as well if businesses understand it. And then we also have a specific employer advisory service as well. So where businesses want advice from the Fair Work Ombudsman in writing, we can provide that service as well. And then obviously the other side of our work is on the compliance, ensuring compliance, so investigating, where people can come to us for assistance, and we'll work through the issues, and that can be resolved at dispute assistance, or it can go all the way through to litigation, depending on the scenario. So it's difficult for us to holistically say that everyone understands the NES, but what we can say, if we look at a data set from, it's a fairly long data set here. We've tried to get sort of a longish picture so that you can get a sense of the numbers. So it's from July 2022 through to the 31st of December 2025. But if we look at our web visits during that time, it's around 153,800,000 web visits. The total inquiries during that time, so people that have come through to our info line or small business helpline or employer advisory service, is around 1.1 million. Now, of those 1.1 million, we estimate around 25% of those inquiries, so roughly 275,000, relate to the NES.
And in terms of compliance issues that you encounter, where do those tend to be in relation to the NES?
Yes. So the top issues from request for assistance is kind of a dispute. So if someone comes to us and says that they don't think that they've been paid their annual leave or their personal leave or whatever it may be, then that's what we call a request for assistance. And the top 4 NES categories, again, those same dates, 1st of July 2022 through the 31st of December 2025. The top 4 are annual leave, public holidays, notice of termination, and personal carers leave.
Very interesting, thank you.
Yes, sorry, it's actually a 5, sorry, I
Okay.
which I missed, which is redundancy pay. So I'll start from the top again. So annual leave is number 1, public holidays number 2, notice of termination number 3, personal carers leave number 4, and redundancies number 5.
Great, thank you very much. Now, something that I think has come through a number of submissions, and certainly did come through the department submission as well, was some technical issues relating to, I guess, zombie long service leave. Just really keen to hear thoughts from people around maybe areas that we could improve the way that works for both employers and employees.
Yeah, thank you, Chair. I'll pass to my colleague, Mr. De Silva Wijoya, to take you through that. There's a bit of history behind that as well.
Thank you.
Thank you, Ms. Barb. There is quite a bit of history. I think the starting point to understand long service leave as reflected in the NES is that the current settings were meant to essentially be a set of transitional arrangements pending the development of a national long service leave standard. And in order for that transitional arrangements to work, they effectively did so by preserving the long service leave entitlements that were in place before the Fair Work Act commenced. So as a result, the way the arrangements sort of work in very high-level terms is that firstly, an employee who's covered by a pre-modern award is entitled to long service leave in accordance with those terms. A lot of the time, they will make reference to state and territory legislation, but it depends on what the pre-modern award says. However, if an employee is covered by certain specified instruments, referred to in the Act as agreement-based transitional instruments, then the long service leave is governed by those instruments rather than the pre-modern awards. And then finally, if you don't have a pre-modern award and you don't have one of these sort of transitional instruments, then you fall onto the state and territory schemes. Now, going to your sort of specific question, the Secure Jobs Better Pay reforms that the government drove through a few years ago provided that the transitional instruments sunset at the end of 6 December 2023 unless there was an application to extend that agreement by the Fair Work Commission. And so long service leave could still arise from those long service leave entitlements. It just depends, and the impact of what those agreements are is dependent on certain conditions. So, for example, if the employee has had sufficient service at the time that it ceased to operate, then you may have a right to take a long service leave under that agreement. So I think if you sort of take a step back, you'd say that there's challenges in working through and understanding what a specific long service leave entitlement may be, and it can lead to a variety of different outcomes depending on the specific circumstances, and you'll see that reflected in the submissions that have been put forward to the committee.
Absolutely, and I guess in terms of having something that is supposed to be pretty universal and easily understood, like the National Employment Standards, that is probably not ideal and probably poses a level of complexity to both workers and employers in determining those entitlements. Is that correct?
I mean, certainly I think there's two policy implications. There's certainly a piece around the challenges that are experienced in determining what the relevant entitlement is, especially by reference to potentially historical instruments. There's not necessarily a clear catalogue of what those instruments are and what they say. But there can also be inconsistent and inequitable outcomes that can arise as well. You may have, for example, different entitlements depending on which jurisdiction you happen to live in, but you also may miss out on the modern long service leave entitlements that may be there in state and territory schemes, which may have more favourable outcomes than pre-modern awards in these instruments, but also can be the other way around sometimes. Sometimes it could be the pre-modern awards might have the more favourable entitlements, and it just depends on what the instrument says, the way that the courts and tribunals ultimately decide to construe those particular entitlements, and that can ultimately determine your outcome.
I think worth adding, obviously long service leave then is governed by states and territories, and so the intent was really about negotiating to bring the national standard. I don't think we can comment on why that didn't happen or sort of what that negotiation looked like given the length of time, but I guess that was the intent of what's in there.
Thank you. And I think that point of equity comes across quite clearly too in the submission made by the department. And to that, again, more on a technical issue as well, some submissions have discussed some inconsistencies that exist or perceived inconsistencies, I should say. This is obviously the opinion of those who've made submissions around the imposition of a 12-month continuous service requirement in the Act before an employee can access unpaid parental leave under the NES. But then there's also the return to work guarantee under Section 84, but only for employees who've taken unpaid parental leave under the NES. So, the argument has been made by some people who've made submissions that job protection, and obviously this would affect largely women workers who we know disproportionately are under the NES. It basically becomes a conditional protection of their jobs. I'm happy to take this one on notice if we need to. It's something that struck me as coming through with a number of the submissions.
Thanks for the question. I think in terms of the 12-month requirement, it's one that indeed has been raised as a policy issue over the years. It is something that is standard across a few different entitlements in the Fair Work Act, and there are probably reasons that could be sort of put forward for or against that in terms of, for example, the stability of the employment relationship. But then, as you point to, there also may be concerns around just access to those important entitlements, especially for women. I think that will be a policy issue that would need to be worked through. In terms of the technical aspects, we're probably not in the position to sort of speak specifically to sort of the legal technicalities in that respect.
Yeah. Thank you.
Probably just to add to that as well, obviously, again, we drawing back to our previous conversation that the NES is, the minimum entitlements, the foundation. It is important to note that there are other protections that also apply for parental leave, particularly in modern awards or enterprise agreements that just as a system kind of work together. Just pointing that out as well.
Yeah, no, absolutely. Thank you very much. Look, I'll leave my lot of questions there for now. And I understand, Ms. Coker, you've got a question?
Oh, thank you. Look, one question related back to the Chair's questions in relation to employment and actually awareness. Do you liaise with unions to update them on position and support them in actually being a conduit to workers and their knowledge of current conditions?
You can start if you want.
Well, I might pass to my colleague, Ms. Maddock. I think there are programs that go to supporting both employers and unions to engage with their members and government funds through the Productivity, Education and Training Fund, both employers and unions to provide information, support, understanding of entitlements and really engage with people to help them to where they need to understand changes in the law or other things that might be relevant to them. So that's probably the primary area of engagement. Ms. Maddock, is there more to add to that?
Hi, good morning. Just building off what Mr. Harb was saying in terms of the approach that the department takes into how it works with our key stakeholders is very much a consultative, collaborative approach more broadly in terms of our role in providing advice to government about the workplace relations systems and policies and programs. And so there's a number of ways in which we engage with unions, employers and broader stakeholders, whether that be through the development of policies or reforms going ahead, but also to that sort of supporting the broader awareness and understanding of the workplace relations system. And as Mr. Hub was saying, we do have a number of programs, one primarily being the Productivity, Education and Training Fund, which provides funding to both unions and employers, being the Australian Council of Trade Unions, the Australian Chamber of Commerce and Industry, the Council of Small Businesses of Australia, and an Australian industry group. And money is provided to them to support their members and the broader community in both understanding, bringing awareness as well. But also our colleagues at the Fair Work Ombudsman have a range of activities that you do with these stakeholders as well.
Thanks very much, Lana. So the Fair Work Ombudsman, we've got a standing advisory group which is made up of the peak organisations, so ACTU, ACCI, Australian Industry Group, COSBOA, BCA, and that is an initiative that the Fair Work Ombudsman Anna Booth brought in. It's also set out though in our ministerial statement of expectations and our statement of intent, and through that advisory group we work through a number of issues. We meet 3 times a year and all topical issues are discussed and worked through. Underneath that as well, we also have a number of, we set annual priorities, largely sector-based, where we are likely to see, our intelligence and analysis suggests we're likely to see the biggest issues or the most non-compliance. And we have tripartite reference groups for all of those priority areas.
Right. Look, you sound like you've got it all in place. I think despite all that, young people still are not aware of their rights often, but we can only do our best. I just have one other question, Chair, if that's okay. It does relate to the fact that one of our key terms of reference is the NES fit for purpose, considering that it wasn't reviewed, hasn't been reviewed holistically since 2012. Do you think that with all the changes that are occurring in this place in terms of work from home, parental and domestic violence leave, changes within casual part-time, is it still working? Is it fit for purpose?
I'll pass to Ms Maddock. Obviously, our submission set. So, we agree with the premise of changing work, and we set out some statistics in our submission that goes to what that looks like. So, I think you're on the money with that one. But I'll pass to Ms Maddock to kind of build on that.
Yeah, I'll just provide some comments to your question based on some of the things that we said in our department submission. So the National Employment Standards, as kind of we've discussed, play a really important role as being that foundation of the workplace relations safety net and being that minimum set of standards that apply universally. And the idea is that they're accessible and easy to understand, and as well as being a set of minimum protections, essentially, that has that sort of meets the community expectations as to what should be minimum sets of conditions of employment. Building on the NES is the modern award system, which provides the ability to provide further detail on sort of the operation of how those national employment standards entitlements work. So you're able to provide further detail around sort of when work is undertaken and the interaction with payments such as penalties and overtime. And you're able to do that to really, and modern awards are sort of done at an industry occupational level. There's 121 modern awards, which kind of reflects the breadth and variety of work that's happening across the economy. And so really being able to have that further detail and awards about how the national employment standards interact with that industry, with that occupation, is really important. So generally we would say that, the NES as sort of that basis of having those minimum protections does sort of work in that way. In our submission, we do provide some comparisons internationally around how our standards compare with other OECD countries, and generally our standards are quite favourable. But our submission kind of also notes, as Mr. Harbour was going to, about some of the changing nature of the workforce and some of the things that you picked up on around working from home, and some of the characteristics and changes in the cohort of the workforce now since its inception in 2009. So, for example, we know there's a greater proportion of women in the workforce. How and where work is done has changed. There's a growth in the workforce, and even the types of industries where there's growth in terms of the health and care economy sectors, there's growth in that section as well. And so this is probably an opportunity for this inquiry to consider, given some of those changes in the workforce since 2009, those questions around is access, eligibility for the standards, still meeting those community expectations of what minimum protections should be at its core. I'd also flag as well is that it's also important for the NES to remain fit for purpose in promoting the object of the Fair Work Act, which in 2022 got amended to include the promotion of gender equality and job security as well. So, as I said, this does provide an opportunity for some of those considerations that are coming through from the proposals as to how the NES can sort of make sure it's meeting those community standards and expectations.
Thank you, Chair.
I think there's also a case to note that the NES hasn't remained static since it was put in place, and there have been changes. Going to the topics that you raised, Ms Coker, about flexible work arrangements and also unpaid parental leave, those changes were made by government to address some of those trends, but as Ms Maddox says, there's an opportunity to take a more holistic look overall.
Yeah, and sorry, I would just further say, going off that, some of the more substantive changes that have been made in terms of paid family and domestic violence leave, that really has come about based on over time how it's developed from being a ward-based provision, an unpaid provision, and then building up to that sort of consensus and strong evidence base to support it being part of those minimum conditions of employment is a good example of how sort of the foundations of the NES have sort of been able to be influenced by sort of, changes in expectations.
Yeah, thanks, Ms Maddox. Thank you, Chair.
Thank you. And Ms Lee?
Thank you, Chair. I've got to rush off to chamber in about 5 minutes, but I just put the question, and if I do run out, please apologise. I represent a very multicultural community in Fowler, Western Sydney. We've got about 27,000 small businesses, and a lot of them are family-run by migrant and refugees. And, I didn't, it was such a privilege to be on this committee because I didn't even know about NES until we start to talk about this. So that's for me, somebody who's quite informed, is not aware of NES. And I'll be very interested to understand, you've got the Small Business Helpline, the Ombudsman. So when I got elected in 2022, I was the first person that actually was able to talk to my small business community and brought the Australian Small Business Ombudsman, because I didn't even know that existed, to engage with my small business community. So how do you engage with those multicultural community small businesses in areas like Fowler? Small business helpline, I can't imagine them picking up the phone and using it because a lot of them are running their own small businesses. And that's really, I know it's the foundation for a lot of the entitlements and stuff. Is there a connection between what they're doing, and do you know if there's a connection or not? And what work is there that's being done within the Fair Work Ombudsman and your department to really engage and inform the community? I know it's a long question. I've got a few minutes, and if you can't answer it all, I've got to leave in a few minutes. Yeah.
Still answer, and it'll be on Hansard.
Yeah, thank you. Yes.
I will pass to the Fair Work Ombudsman, probably just at a general level first from us. The Productivity, Education and Training Fund is the key point in which government funds small businesses support their understanding of the workplace relations framework. That's through COSBOA, and COSBOA does a lot of work to engage with small business.
Can I tell you, I know because I work with COSBOA, BCA, none of those organisations actually connect with my community in Fowler, in Western Sydney, full stop. Because it's just two levels. It's, we understand the small businesses that COSBOA and BCA represent. It's definitely very disconnect from, they've tried to come out a few times, but we've never been able to really make that happen. But yeah.
So in addition to that, there's been funding provided by government to support small business services. Generally, those services delivered through the Fair Work Commission or the Fair Work Ombudsman. So probably a good point to pass over to the Ombudsman.
Yeah, I'm happy to talk to that. Thank you. And I acknowledge there's always more to be done, certainly for small business. We've mentioned the Small Business Helpline. We also have a dedicated small business showcase on our website as well. We do outreach programs like webinars where we invite community members. We rely on our reference group representatives as well as the advisory group members to share the message for us. The resources that we develop, we also try and co-design as well through that consultation process to ensure that we're meeting the needs. We understand small business are time poor, so obviously everything we do is as high level and as plain English as possible.
Yeah.
From an accessibility perspective, which you mentioned, again, always more work to be done, but our entire website and the Small Business Showcase also is available in over 36 languages. That's sort of an automated translation function. In addition to that, we have a dedicated in-language resource section. So again, we listen to the community about the needs of education resources. We try and respond to that. And where there's an additional need for our called community, we have those professionally translated as well. We try and do a series of sort of different offerings as well. So we've got our videos on the YouTube channel for people that are time poor. We incorporate modules into our online learning centre so that small business for induction programs can essentially just download the online learning courses for their staff. Yeah, look, as I acknowledge, there's always more to be done. We do have dedicated communications campaigns as well. So we've got our organic corporate channels that we use and we post several times a week. But we also develop tailored paid marketing campaigns to sort of extend that reach to the small business community in particular.
Just one last before I rush off. In language is really critical, and a community like Fowler, they're not digitally engaged as well, so they would not necessarily turn to a website to look. So it's about face-to-face connection, and that's what I brought the Australian Ombudsman to come out, and they really loved that because they didn't know that existed. So thank you so much. I'm sure there's been more to be discussed. Thank you.
Thank you so much, Ms. Lakeman.
Thank you, Chair.
Thank you. And Ms. Fernando, I believe you have a question.
Thank you so much for being here. Are there any concerns that certain cohorts, such as young workers, casual workers, or those in high turnover industries such as retail, fast food, are less able to access and enforce their NES entitlements in practice?
Yes, thank you for your question. I guess I would go to, it does come back to the education and then always more to do, but making those cohorts aware of the resources that we have available to then educate them, to then empower them. I think through the amount of inquiries we receive through our info line is sort of, we try to empower people to voluntarily comply with their provisions, and so the resources we're developing are supposed to empower people to then raise those questions with their employers, and equally we target the employers as well to essentially understand their obligations. I don't think that answers your question properly, but have you got anything to...
It's a hard one to answer in that I guess what we can talk to is that we know that we've had really high levels of engagement via our website. I think I said before it was around 153 million visits since between July 2022 and end of December 2025. So we know that there's lots of visits going there. Now out of that, it funnels down to around 1 million inquiries, so people that might call us. Now, what you can correlate from that potentially is that it's a fairly small percentage of people that are coming to us that need to then either need further assistance, have a dispute or an issue, or just want to double check the information or how it relates to them specifically, from the website. So it's difficult to say whether or not there are still gaps. I guess, that's what might be explored through this inquiry as well.
We do certainly rely on our reference groups as well, which are, targeted at our priority areas. And through our, obviously, union representatives, employer associations, they're a very powerful source of identifying information gaps, but also assisting us in co-designing those products in response to the issues they raise with us. So that's been, like I said, a really powerful channel to target and tailor the information for those industry sectors, but also those customer segments.
Thank you. And my last question is, as AI and automation reshapes jobs, how well positioned is the NES to manage increased job displacement and transition, such as in sectors like retail, hospitality, warehousing?
Happy to start on that one. It is a really good question, and I think again goes to some of the statistics that we provided in our submission around the changing nature of work and how we're obviously focused on how AI is playing a role in doing that as well. Probably the key pieces of information I'd point the committee to is the government's National AI Plan, which was released on, I think, the 2nd of December 2025, so quite recently. Really sets out how the government is positioning Australia as a leader in responsible, inclusive and innovative AI development and adoption. Part of that for this department is really how that impacts on the labour market and supporting safe and cooperative workplaces. There is an aspect of the National AI Plan that really is in this department's responsibility. So our focus is obviously across the department of a focus on lifting AI skills and capability for Australian employers, and that includes small business as well, and thinking about transition and in particular occupational transition without deferring too far. The Jobs and Skills Australia released a Gen AI report that you might be across, which goes to providing a bit of an insight into how the rollout of Gen AI is impacting on workplaces and potentially what that looks like. And obviously the workplace relations framework being quite important to uphold rights and protections for employees. The framework itself is generally we consider to be technology neutral, and is adaptable to different circumstances that AI might throw up. Obviously that doesn't change that we are focused on understanding that better and trying to work through with our stakeholders how that might impact. And there are a couple of different areas of the NES that this kind of does intersect with. So generally the areas of focus, which I think you've heard from submissions, but through previous conversations, is around consultation and transparency and what that looks like within the context of an enterprise and its adoption of AI. In terms of redundancy and transition, again, what role at the enterprise level do employers play in supporting people to transition from AI, and the NES plays a role there in terms of its redundancy provisions. And the other aspect, I think, is job redesign or job design, worker intensification, discrimination, bias, those sorts of issues that are inherently part of the existing AI as it's still developing. Obviously draws on the biases that already exist in the system, and that's an area of caution that we'd focus on as well. So we're still working through those kinds of issues. We have established an AI working group which sits under the National Workplace Relations Consultative Council, and we've had a couple of meetings since October 2025 on that, really to work through those issues, understanding what the gaps are, and I think you've got a few submissions from the community on these sorts of issues as well. So that's probably where a lot of our focus is at the moment.
Thank you.
Thank you. And I guess the previous iteration of this committee in the 47th Parliament undertook an inquiry into artificial intelligence and work, so it's clearly a hot topic. And I might just quickly extend some of this conversation from Ms. Fernando's question. Obviously, there's been transitioning workplaces before artificial intelligence. This isn't new. Automation and other kinds of changes. So how has the NES, I guess, dealt with that in the past? Like, how has that been useful to kind of inform when we've had if we're talking about the disruption of AI potentially, we've had workplaces disrupted before and that affecting redundancies in other kinds of entitlements and consultation, etc. Yes. Like, how's that been handled?
Yes, I think as I said, we're still working through what they look like from the department's perspective. Obviously, as you say, transition happens over history, and it certainly will be something we'll look at. We haven't quite gotten to that, but we are looking at that. Also looking at the experience of other countries as well, and what the international kind of posture looks like in this context.
But it hasn't come up before in terms of, other areas where there's been automation in the past with NES employees?
I think the uncertainty of AI and how quickly it could, impact on jobs and redesign is unclear. Obviously, there are estimates that are quite conservative and limited in terms of the job impact, and then there are others which are quite high and a little bit more alarming.
Sorry, just to clarify, I'm sort of asking about sort of past experience of the application of the NES, where there have been transitions in workplaces where there's been automation, for instance, for NES employees, or other kinds of changes, because I know, it has happened.
Yeah, I might pass to Ms. Maddock.
I guess it's going to that the NES is sort of that base set safety net of those entitlements, and so for some of those issues around entitlements around redundancy, for example, they've sort of been able to be applied kind of so that it applies consistently across all industries and all employees. So you would kind of noting that the NES has been in its form since 2009. Yes, the rise of digital technologies has been something that's kind of been happening throughout the economy since that time. But the NES has kind of been there to act as sort of that minimum standard in which then either through awards or through enterprise bargaining as well at the enterprise level has been able to sort of adjust or negotiate to adapt where sort of specific changes have happened at an enterprise level or industry level as well.
Can I just ask a very explicit question to follow on from this? So does the department have a view that safety net with regard to redundancy needs to be increased?
In regards to what?
In regards to redundancy, I don't think we have a view. I guess that's the role of the committee to consider the submissions. It's your difficult job, so I don't think we would. So
that's not the department's position. Is it something you're looking at, but you don't have a position on?
I mean, we're engaging with stakeholders on that probably in a similar way to you are here. Obviously, we're at that point where we're trying to understand what it looks like and the experience of people, real people on the ground. But at this point, I think that's not an area that we have a view on.
Yeah. Thank you very much for that. Did anyone else have any questions?
Through you, Chair, just in the space of non-compliance, and you mentioned a little bit of a shopping list of annual leave, public holiday, termination, etc. Are you seeing a pattern specifically through vulnerable workers, and what type of so when I say vulnerable workers, obviously I'm thinking migrants, young people, casuals, and also is there a pattern within maybe particular industries as well? Is there something emerging in that space that you could share?
I think from a compliance and enforcement perspective in the Fair Work Ombudsman, obviously we have that enduring commitment to prioritise vulnerable workers, which I think includes the cohorts that you describe. Unfortunately, with a lot of our priority sectors, even when we return, we find that there are still, high levels of non-compliance. So I guess the key is trying to work on how we can improve those levels of compliance. But in terms of our enforcement outcomes, we've obviously got litigation is our most high-level enforcement outcome, and we use that routinely. Usually focused where there are, serious or systemic non-compliance as well, and it is, very often the case that it will be vulnerable cohorts, upon which we take that sort of litigation. So, we have many litigations in the frac industry relating to, migrant workers, etc. as well, so they can continue to be a theme through all of our litigations.
And just to go to that question of the specific industries, so for the last financial year, so for 24-25, the top 3 industries for disputes completed were accommodation, food services, which made up around 16% of the disputes completed. Construction was 14%. Healthcare and social assistance was 12%.
Thank you, Chair. Thank you. Mr. Swan.
Thanks, Chair. Just another question, folks. Some senators are quite fond in this building of carrying around the entire Fair Work Act and regulations and printed out. It's about that high. Is there an opportunity through this process to skinny that up by a couple of 100 pages? Because...
The Act does fall slightly outside this inquiry.
Exec summary, basically, because it's not just. I think to Ms. Fowler's, Ms. Lee's point, it's sophisticated employers as much as less sophisticated sort of small business employers that have really struggled with ensuring that employees are afforded everything they're entitled to through both the NES and as it translates through awards and whatever. Can we reduce that complexity at all? Are you seeing opportunities there, or?
Yeah, it's a good question. I think probably, and I'll pass to Ms. Maddock as well for some more detail, probably at a high level, and I know you've already heard it through the submissions that you've received, but there is inevitably a balance between how prescriptive you are in the Fair Work Act and the framework versus less prescriptive, and really that balance is if you provide more detail and information for people to understand their entitlements, you can have a big book. If you provide just a high level information, you might have a smaller book, but then you may not have a very clear set of obligations. So I think it's inevitably the challenge of that balance, and I know your submissions will go to that as well. There is an example. I'll pass to Ms. Maddock. There is an example of how that's worked in the modern award system. But
I think I'll just go back to sort of the intent of the National Employment Standards. Broadly, they are sort of designed and written in a way to sort of provide a simple explanation of the minimum standards, and so it doesn't provide for every scenario in which that entitlement might be used in a workplace. That's sort of that's enabled to be dealt with in other mechanisms through awards and enterprise bargaining and such. And so at its heart, the NES itself, when designed, was written to sort of as much as possible kind of just provide the base legally enforceable sort of core entitlements. The example that Mr. Harbour was discussing in regards to sort of the balance between what people perceive as useful or complex is probably in regards to when the Fair Work Commission was undertaking a matter in terms of reviewing some modern awards in terms of that easier to use type approach, and they've previously done work in the modern awards system to sort of rework and awards into sort of plain language as well. But what they were finding from stakeholders was awards can contain classifications and pay structures. Some stakeholders will say that provides clarity. Some people would say that's just provides that's rigid and there's not the flexibility that they want. And so I guess the outcome was that there wasn't sort of a consensus of what's the right balance to apply broadly across a certain industry, occupation and award.
Thanks.
I think just to build on that question, if I may, as well, I mean, I think, obviously there's a lot of work that goes into education and guidance and getting that balance right and making sure people understand both their entitlements as workers and their obligations as employers. But are there any particular areas in the NES that do create recurring compliance challenges despite your best efforts?
Yeah, and I think that's really the crucial role of the Fair Work Ombudsman in providing that.
I think going back to the example that was raised earlier around long service leave is a good one, because while it is true that most people do derive long service leave entitlements from state-based legislation, when people come to us at the FWO, because of those transitional arrangements that have been referred to earlier, the first step that we have to do when we're trying to assist someone with a long service leave inquiry is see whether they've got that derived, there's entitlement from a pre-reform award. So that's irrespective of the fact that we know that most people will actually be reliant on a state-based legislation for that entitlement. So that, I guess, does add some complexity for us in being, in administering and providing that advice, because we have to work through that step with every customer that comes to us for advice.
Could I ask a follow-up?
Yeah, of course. Ms Coke has a follow-up question there.
I was interested in asking the Fair Work Ombudsman, if there is non-compliance, are our enforcement tools, such as litigation and enforceable undertakings, are they sufficient to deter non-compliance, and is there more that needs to be done?
Look, I think obviously, litigation is our, at the apex, I guess, of our enforcement tools, and with our strategic enforcement approach, we do, try and assist, I guess, voluntary compliance, and then, working up the apex of that
always preferable.
Yes, absolutely. And a lot of the time, we are able to assist customers, whether it's through voluntary compliance or assisted compliance. We've got a universal dispute assistance function available to people to come to us as well, so that, we can assist hopefully in resolving their dispute. But I think litigation will always be an important enforcement tool, not only from a specific deterrence angle in relation to the particular parties that might be involved, but also as a general deterrence as well, and where there is broad public interest in relation to a particular matter. And I think a number of the submissions have raised particular examples. Obviously, we've got the ongoing Coles and Woolworths litigation in relation to annualised salaries as well. So I mean that continues to have significant, impacts for everybody in the national workplace relations system beyond those parties to that litigation.
I was just going to add, I think Rachel's answered that really well. The vast majority of our matters are resolved through that dispute assistance process. So, for those pointy end tools, enforceable undertakings and litigations, we're really looking for, really exploitative behaviour that's occurred in those priority sectors. And the vast majority of matters that we deal with don't have those behaviours. There's a lot of, often a lot of emotion from both sides when they come to the Fair Work Ombudsman when there's an issue in the workplace. Work is a very, important part of people's lives. It's part of their identity. For small business owners, they've got a lot riding on this as well. They've often, mortgaged the house or what have you. So there's often tension when people come to us, but the vast majority of issues we resolve through dispute assistance, and our focus is on trying to, if there's been an underpayment or an errant issue, on trying to get that resolved and make sure that the employee is going to be paid accurately and correctly going forward, but also that the employment relationship can continue and be productive going forward as well. So, I think we had 70 odd litigations last financial year, but as Ms Volsky said, really that is for that particularly exploitative behaviour, or where there's a lack of cooperation with our attempts to try and resolve the dispute.
Now, I'm very sorry, but I think we're going to have to end everything here because the bells are ringing for the House of Representatives. So I'd just like to thank you all for your attendance here today, and there may be opportunities for us to put some questions to you on notice, and I hope that would be okay. Thank you. So you will be sent a copy of the transcript to request any required corrections, and I declare this public hearing closed. Thank you very much.